Good timing.
Went right along with
So I went to law school, passed the bar. I opened up a law firm here. I specialize on business law, using my MBA and my law degree to help entrepreneurs, startup businesses, and small business owners. Sort of anywhere from what sort of business entity should I be and what should I do, all the way through got to a point where we need to start adding employees, grow, become successful, help me get to point B. And so I'm that kind of guy. So today we're here. We're going to talk, most of you guys are LLCs, limited liability companies in Florida. If not, thinking if you might become one. So today, a new LLC, what does it mean to me? An overview of the Revised Act. So, as all lawyers do, I have to give you a disclaimer. Nothing radioactive, but this whole presentation basically, well, two disclaimers. One, this is the most words I will put on any slide ever. I think PowerPoint is a tool, not a crutch. So I will keep you entertained and amused and make you have to listen to me. You can't just read and go to sleep. But basically, this is all for educational purposes. Every situation is going to be a little bit different with every person. So at no point have we established an attorney-client relationship here, unless you want to give me money or put some in the jar. And everything here is sort of educational, so please don't rely on it, as Google. Roadmap of what we're going to do today. Very quickly, we're going to start with just an overview, a general overview of different business entities that your businesses can be. A little bit of the history of the limited liability company, both overall, then specifically in the state of Florida, obviously what's important to us. Then we'll talk about some of the benefits of the LLCs. Some of you might be LLCs and not knowing why you're that. Someone told you to be that. You read on Google that you should be that. We'll talk about probably why you are an LLC, why you should be an LLC, or maybe why it's not the right entity for you. We'll do a brief overview of this new act. We'll talk about some of the things that are going to change. What are the really important things that you'll have to know moving forward? Since things change, we'll talk about some things that are going to remain the same. And then you'll be free to go. So we'll try to keep it short, keep you something. So the first thing, everyone says, I'm a small business owner. Isn't a business just a business? It's not. There is a laugh track that did not go off, but there was supposed to be. No, business is not a business. And what do I mean by that? This is an example of the different business entities that you can have in Florida. A general partnership, a limited liability limited partnership, a professional limited liability company, a corporation, a professional association, a sole proprietorship. There are a lot of choices. Each of these might be the right choice for you. It really depends on the situation. So each industry has something, everything. I am a PLLC, a professional limited liability company. So this act will apply to me, even though I have a P before my LLC. So what we'll focus on today, obviously, since everyone's here, hello, we're all LLCs, or we will be, or hope to be. A brief history of the LLC. Who knows what flag this is? Wyoming. Yes! First LLC statute in the United States was in Wyoming in 1977. Although they'd been around in Europe and everything, the United States started in Wyoming. Obviously, none of us live in Wyoming, yay for us, so we'll worry about Florida. Florida, 1982. We were the second state, actually, to enact an LLC statute. So we've been on the forefront of sort of this whole limited liability company wave. So how did we get from 1982 to today? Well, in 1993, there were some changes to the act, substantial changes. That was David Bowie, just in case you're wondering. In 1999, more changes, more Bowie. And the big thing that happened in 99, this is really important where things started to take off, the corporate income tax on LLCs was eliminated. So we'll kind of back up and do a 10,000-foot view here to kind of talk about why that's important. So corporations are subject to what's called double taxation, which means is the business entity, any sort of profit that they make gets taxed by the government as a corporate level, and then as the money trickles down to the shareholders, once they claim that, it gets taxed again. So they get taxed as a business, and the money comes down and it gets taxed as the individuals. So the LLC used to be subject to that corporate income tax as well. Well, in 1999, what they did is they eliminated that. So now what the LLC does is it pass-through tax, which we'll talk about, and it gets taxed only at one level. So at that point, now we get the limited liability of the corporation without having the double taxation. 1999, it really starts to take off in Florida.
Excuse me.
Yes?
Is that federal or state?
What?
The tax, business tax, is that all federal or is it state tax?
Both. There is both of them there, yeah. But they eliminated the state and then the federal, there's the federal statutes, but this is all at a state level and run, so. But the corporate tax, they eliminated. In 2005, there were more changes to it. The complete rewrite now. So now total today, there are about 700,000 LLCs in Florida. We did a search this morning trying to find, okay, what percentage of that is businesses? About 2 million or so small businesses, so a little over 30%. And like I said, over the last 20 years, it's been the entity of choice for a couple of reasons. Hopefully you guys know of, since most of you are LLCs. If not, we'll talk about why is the LLC really grown in popularity from 1999? Why has it become the entity of choice that it is in Florida, as well as in other states? Well, the first reason, it's a fraligator. No, it's a hybrid entity, which means, see, I told you, there's nothing really, if you were just to watch this PowerPoint, it is useless to you. You have to listen. So it's a hybrid entity. What I mean is it's a little bit of, it's a little bit of corporation, and it's a little bit of the partnership. In this sort of sense, you get the limited liability of the corporation. Basically, there are members, just like there are shareholders in a corporation, there are members of an LLC. They have an interest in the company, and they are not personally liable. The other side of it, we talked about in 1999, they got rid of the double taxation. Now it's just pass-through taxation. So what happens is, if you have an LLC, it basically gets taxed as a partnership. The profits will pass through to the members, and then it gets taxed at that level. So it's a nice little bit of both worlds. They kind of took the best of both worlds, made us the most dangerous creature, the fraligator. And then the other reason, like I said, is the liability. This is really the main thing. It's in the name of the company. It's a limited liability company. So basically what this means is that we have the business owner and all of their personal assets on the other side. If I want to start my own business, I'm going to set up an LLC. What it is a shield. It protects any of my personal assets from claims against the company. So whatever the company does, if there's any liability coming through, as long as you are smart and you don't commingle, there's a clear distinction between personal and business. Where a lot of small businesses run into problems is they don't set up separate bank accounts, separate tax IDs for their LLC, they commingle funds, they use personal funds for business, they use their business account to buy groceries, and at that point you've kind of taken away this shield and you're really sort of opening yourself up to liability. At that point you've kind of really gotten rid of all of the benefit of the limited liability company. So the real crux of it is this shield to protect your personal assets. You can create a business. If something happens at the business, then your personal assets, they can have whatever's in the business, personal assets remain all of yours. So this, FR, the Florida Revised Limited Liability Company Act. Lawmakers, lawyers, we all like abbreviations of everything, just like every act has a name that's abbreviated. This one doesn't spell anything cool. But signed and passed in 2013. They started the committee back in 2008 to start talking about revising this act. What they did to revise it is they looked at the Delaware LLC Act. Delaware is one of the front runners as far as business entities go, due to their court structure, their case law. If you talk to any major corporation, is probably incorporated in Delaware. Coca-Cola, all the major big companies are incorporated in Delaware for all the perks of that. So Florida looked into their act. They looked at the Uniform Act. So there is a uniform set of statutes that basically a bunch of lawyers get together and create very legal-easy uniform laws. They looked at that to go off this. And it was signed by the governor in 2013. What it does is a couple things. It creates a whole new chapter of law. If you guys want, we can just start reading that. It's 140 pages. I have it in this book. And it creates this whole new law. And basically, it became effective on January 1st, 2014. The current LLC Act is Chapter 608. That gets repealed effective January 1st, 2015. So we can do the math. There's a year there. There's a transition period. So let's talk about kind of since we're in that transition period, how that's impacted. If you had an LLC that was created before January 1st, 2014, you are in the transition period. You are still controlled by the old 608, the old LLC Act, until it gets repealed. January 1st, 2015, you will then be subject to the new act. You can choose to be an early adopter of the new act, hence the early adoption. And what it is, it's an all or nothing sort of thing. You can go full-fledged anytime between now and December 31st and say, based on your operating agreement, we're going to be controlled by the revised Florida LLC Act. However, if you've created an LLC very recently in your new business and you created your LLC after January 1st, 2014, I happen to be one of those, then I already am controlled by the new revised LLC Act, 605. So we've kind of talked about this. Why is this all important? Let's really get to the meat of it. Well, it's important because both the old LLC Act and the new LLC Act are what they call a default statute. What that means is it is a gap filler. Now the pictures start to make sense when you hear the words, right? Gap filler. So what that means is if your operating agreement, so let's take a step back from that. An LLC, in order to become an LLC, files documents with the Department of State, Division of Corporations. You file articles of organization, you give them some money, they give you a document number and say, congratulations, you are now a Florida limited liability company. You could just stop there and you would be fine. You would be controlled and everything that you do would be controlled by the Limited Liability Company Act. However, most LLCs will set up what they call an operating agreement. To the corporate world, the equivalent is the bylaws. What the operating agreement is basically it governs how the LLC is going to run. What sort of powers the members are going to have, the manager is going to have if there is one, how they resolve disputes, membership interests, transfer of interests, almost anything. So every LLC, even a single member, should have an operating agreement. What the default statute says, and what the default statute is, this new LLC Act, if there are any, we all. So they've created this new act. Let's talk about some of the things that's going to be important and some things that you guys should be aware of. Non-waivable provisions. Like I said, it's a default statute, which means if your operating agreement does not address a certain issue that's in the statute is the governing law. It basically puts words into the agreement of your company. In the old act, there are 6 provisions that were unwaivable. Means every LLC within the state, no matter what they put in their operating agreement, this was the law for all of them. Six provisions. They've upped that now to 17 different provisions. If you really want, you can find all of them in chapter 605.1 or 0.01.05. Some of the major ones that have come up, applicable law. So you can't say in your operating agreement, we choose to be governed by the law of Utah. You can't change the applicable law. You're governed by the rules of Florida. Capacity to sue or be sued. You can't write away your sort of liability as an LLC. You can't say, well, if we do something negligent, you can't sue us. We all agree that none of the members can sue, no one can sue. You can't do that. You can't sort of give up that sort of liability. The power to associate. This is actually something new too. What dissociation is basically when a member of an LLC wants to say, I don't want to be a member anymore. They want to get out of it. Before, you weren't allowed. Well, you were, but it was very hard to sort of get out. You had to buy out and everything. Now, for any reason, you can dissociate. You cannot put in a provision in your operating agreement stopping people from doing that. So if you have a member of your LLC under the new agreement, if they want to dissociate and no longer be a member, you have to allow them to do that. Restriction of access to information. Same sort of thing. We wanted to be more friendly in Florida, get people to stay, because a lot of people were going to different states, Delaware, to sell at their LLC. So we said if there's a member of an LLC, you have to allow them access to the information of the LLC, the financials, the bookkeeping, all of the documents. You can't say these are locked off, only certain members are allowed to see them. Everyone has to have the access to the information. So it opens that up a little bit. And finally, the other main one that I put on here is the winding up requirements. So what winding up means is basically closing down the LLC. Winding up is selling off all of the assets, all of the property, sort of making sure that the members get their membership interest back that they put in, their money, their contributions, and then you just file a document with the Department of State and say, we're dissolved, we wound up, we're no longer an LLC in the state of Florida. And so you can't sort of change any of those requirements. Those are default by statute.
Question about the power to dissociate.
Yes.
The state says you can't prevent people from dissociating. Can you still write into the operating agreement how it needs to be done?
Yes. There's a little bit of wiggle room. Basically, if you give express written, if you write in writing, say expressly, I want to dissociate, you have to give it in writing. You can add some other provisions into it, but the one thing too to note that this importance that you asked is, even if you dissociate, you're still liable for any action of the LLC when you were a member. So you can't try to get out of liability that way, and that's another one of the provisions that you can't write off. You can't say, okay, if you dissociate, you're free from any liability, waiver, indemnification clauses or anything. So there's some wiggle room on how, but it's just basically written in sort of express. You can't think, oh, you haven't participated, you're out. It has to be written express consent. This is a big thing in Florida. So Florida was unique. So an LLC can be, in most states, could be either manager managed, which means you have all the members of the LLC, just like your shareholders of a corporation, and you have your manager, your board of directors per se, and then, or you could be member managed, which means all of the members had rights to manage. There would be a vote and everything. Well, Florida had this weird little thing called a managing member, which basically meant it was member managed by the whole group, but we would pick one of the members to be the managing member. In the new act, they're eliminating that. There is no longer a managing member. So if you're an LLC, which might possibly be written in the operating agreement that there's a managing member, by default, come January 1st, 2015, you will now be a member-managed LLC. So that might be something that your operating agreement might want to address and make manager managed instead of being the member managed. So that was a big one in Florida. Appraisal rights. So what appraisal rights are? When an LLC forms, all the members come in, they bring in membership interest, basically money. What appraisal rights are when the corporation is winding up, dissociating, or merging. Basically, appraisal rights are when the members say, I want my right share of what the company's worth, I want my percentage of the contribution that I gave into the LLC. So before there were 2 triggers really for the appraisal rights. They've now upped that. There are 7 triggers, merger, some of the other things you can go ahead, we don't need to go specific, but just know that now there are additional ways that members can ask for appraisal rights. And sort of, that means the company will have to be get an evaluation of the company, and they would have to be paid their rightful share based on their membership contribution. And then inaccurate information. So before, when you would file the documents with the Department of State, Division of Corporations, you would file your registered agent, your location, your annual filing reports, all that. In the old act, they're presumed to be signed under penalty of perjury. So you're all old enough to remember the Bill Clinton, we know what perjury is, lying on the stand. There we go, okay, we're awake still. Now, basically what it says is anyone who signed the document, who forced someone to sign the document, or a member who knew that the document is incorrect and didn't correct it is liable. Any document that's filed with the Department of State, which are your articles of articles of organization for your annual report, which must be filed every year. If there's any incorrect information, registered agent, address of the corporation, if a third party relies on that public information and they are harmed, you could be liable if you're a member, if it's a member managed, or if you're the manager, if it's a manager managed. So there is some liability there now to kind of make sure that all of your records filed with the state are correct, where before there was a lot of leeway. And the last thing, they've added a statement of authority. What this means is there is a parent authority in an LLC. If you're a member of the LLC, everyone thinks, okay, you have the authority to bind the LLC in a contract. So if I'm a member of ABC LLC, I can go sign a contract with a third party with office divvy to rent space, and then I can just kind of go away. Well, the company, the LLC, will be responsible for that contract because I was a member, I had a parent authority. What you can do now is you can file with the state so it becomes public information, a statement of authority, saying, I, as lawyer Mike DP LLC, grant authority to Jillian Griffin to bind my LLC in the following capacity. Well, that becomes public knowledge, so third parties are now put on notice that Jillian has authority to bind my LLC. Well, if the person who's granted authority says, I don't want that responsibility, they can file a retraction with the Department of State saying, yeah, thanks, but no thanks, I don't want that anymore. So now third parties can be put on notice specifically of people who will be have the authority to bind the LLC. Those things that change, some things still don't change, because if it's broken, I fix it. So some of the major things that didn't change, the charging order. So this is something that, what a charging order is. There was a Supreme Court case in Florida in 2011, and they created this provision called the Olmstead Patch, which got handed into law. They brought it over into the new act. So what a charging order is if there are members of an LLC, and they have a personal creditor. So I'll use myself as an example again. So Mike Davis, in my personal private capacity, I default on my credit card payments. Well, the credit card company says, we know that he's a member of this LLC because I found it online, it's public knowledge, he's the owner of Lawyer Mike DP LLC. There's money in the LLC, I want his money. The only remedy, and the sole and exclusive remedy for a creditor of my personal against the LLC assets is what's called a charging order. And what this basically says is the court puts a charging order on me personally and my interest in the LLC. And if I get paid any distributions from the LLC, that personal creditor gets access. They basically come in front of me and they get to be in charge. They get in front of me, they get placed first. So this is something that stayed. So personal liability, if I default on something personally and I get distributions from the LLC, those could be subject to that personal default under the charging order. So that is the sole and exclusive remedy for a personal creditor to go against the LLC, the interest of the personal member in the LLC. So that stayed in from 2011.
But only on distributions. They
Yes.
can't go after assets of the
They can't go after assets of the LLC, no. But if you wound up the corporation and then distributed it,
Okay.
that would be, yeah. But so if the LLC doesn't make any distributions, they can't get anything. So, yes. The fiduciary duties. So, I realized after going to law school for 3 years, I knew what fiduciary duties, but when I did this presentation for my fiance, she said, I don't know what that is. So fiduciary duty, in layman's terms, or in just normal English, it's not even layman's terms, is basically you are representing the interests of someone else in your personal capacity. So, once again, I'll use myself as an example. So, Mike Davis, as manager of Lawyer Mike DP LLC, I have a responsibility to act in the best interest of the LLC. So in that capacity, just like a CEO is expected to not, if in their capacity, they work for the benefit of the company, to help the company grow, everything. So that's what a fiduciary duty is. It's the duty to work on the interest of someone else. For an LLC, there are really two major ones, the duty of loyalty and the duty of care. Basically what the duty of care says is you can't, it's unreasonably negligent, no full breaking of the law, anything like that. So all that sort of stayed in that there are fiduciary duties of members and managers for an LLC.
Is that all members?
Mm-hmm. Yeah, so you can't, if you're a member, there are some wiggle room, you can get rid of some of the fiduciary duties, but you can't eliminate all of them. A lot of times this will come up with outside third-party deals. If you bring a deal and it's presented to the LLC, sort of the time frame for you to be able to, in a different capacity, scoop up that deal if the LLC chooses not to. That's really the major case law that you'll see on it. And the apparent authority stayed. Like I said, if you're a member of the LLC, shelf LLCs, no shelves. Everyone knows the elf on a shelf? Mm-hmm. Okay, so we get it. Come on, gotta wake up. I know it's
No shelves.
no shelves. That stayed. it wasn't in Florida, it is in the Uniform Act, but Florida has said no shelf LLCs. What a shelf LLC is basically an LLC that has no members. Kind of like domain brokers, I'm going to buy unicorn.com for when everyone discovers that they are in the Amazon and they're real, and then in hopes I'll sell that website. So sort of the same thing with an LLC. I'm going to create an LLC called, lawyer Mike B, because another lawyer is going to come and I'm just going to hold on to it and then I'll sell it to him, try to make some money. Florida doesn't allow that. If you sign the Articles of Organization, you are deemed to be the member, and it's kind of presumed that you are the member of it. So there are no shelf LLCs. You have to have at least one member in all of the LLCs. And the other thing that didn't change, we brought back the Fraligator. It's still the hybrid entity that it kind of grew, gained all the steam that it had beforehand. A little bit of a partnership with the taxation and the liability protection from the corporation. All right, so everyone's saying, okay, that's all good and dandy, what's right for me? Like I said before, I can't really tell you right now. It's not based, no matter what you read on the internet and Google and say, I'm an accounting firm, I'm a single person doing a yoga studio, what should I be? And you'll find forums and everyone says, well, I'm this and I'm this. It really is specific to every person. And it's not just a lawyer's decision. It's not just your decision. This is a team effort, really. You want to get the accountant, your business's accountant, with the owner and the members, and sort of a lawyer to sort of all get together and figure out, where are we? What are we looking to do? Where are we looking to go? Because a lot of times the future will have a really strong bearing on whether, if we're looking to go public, if I got the next Google and I'm looking to go public, it's probably better for me to be a corporation than an LLC for a variety of reasons. And then if I'm doing something where there's no real liability, I'm just going to do sole proprietorship. That could work for, there could be two people from the same industry and we could have totally different sort of requirements that they need, because everyone knows every business is a little different. So at this point, I suggest, if you want to know if your LLC has an operating agreement, which hopefully you should know, and not me, review it with a lawyer or someone kind of knowing, here's what the new things that are going to change, does any of this apply to me? And if you want, I happen to know a lawyer who does all of this sort of stuff. Hi. So we are going to do, I'm going to do a little drawing to kind of wake everyone up. So did everyone put their card or sign into the sheet? Okay.
Mike, if you've got a miracle Google on your hand, how long does it take to go from LLC to corporation?
I can do it. I can file paperwork, and it depends on the state. Just filing the.
Does it take much more than like a half a year or something?
Yeah, you can convert it anytime.
Well, we're on a mini break. Anybody would like a water?
Cookies. Get some sugar.
Everybody good?
So I need coffee. Okay. So what the drawing is going to be for, like I said before, I'm a business attorney. One of the things that I offer is a general counsel program. All of the major corporations, I use Coke again because everyone's drinking it, and we talked about it earlier. Coke has a team of lawyers, not just one, they have a whole department. McDonald's, a team of lawyers. If those big guys can have a lawyer, why shouldn't the little guy have a lawyer? I think they should. So that's kind of accessible legal counsel. That is Lawyer Mike D. That's what I'm all about. I offer a general counsel program. What that is, kind of like what Kay was saying, it is prepaid, discounted, billable hours. Kind of use for whatever you need. If we want to go over the operating agreement and make sure that it's up to date for the new LLC Act, we can do that. If we want to create an operating agreement, we can do that. Employment agreements, reviewing lease documents for various things, sort of almost anything along the spectrum. So what I'm going to do is draw a business card, and that lucky person can have a month of free service under the general counsel program.
That's awesome.
Daniela.
Yeah.
I only read so I
Okay, okay. I didn't draw it, but I want to. Cool, does anyone have any questions?
So is there anything we actually have to do for the transition, sorry?
Not necessarily. No, I mean, there's nothing absolutely required. Like I said, if any of those things apply to you and some of the other changes, it might be worthwhile to update your operating agreement to make sure that if you were a manager member, if you don't want to be member managed, sort of that. It's worth going through your operating agreement and just sort of making sure that everything's in there. Like I said, the non-waivable provisions went from 6 to 17. So if you had some of the ones in there, one of the 11 that grew and you got rid of them, they won't be in there anymore. So there's nothing you can do about it, but it might be worth knowing. For the most part, small companies aren't going to be impacted greatly, but it's always worth looking over and making sure, because now you know, even no matter what your operating agreement says, this statute is a default, so it will fill in all the gaps on stuff you're missing. So it's worth taking a couple minutes and going through and making sure you're up to date.
If you had like 70 members in your LLC, are all of them, do they all have a fiduciary responsibility to the LLC?
Yeah.
Okay, since managing member has now gone away, if you're signing on behalf of the LLC, I've always signed Lillian Villanova, managing member. What am I signing now to make sure that I'm signing as corporation and not myself personally?
Well, as of right, you have until December 31st, you can continue signing as managing member. That term is there in the transitionary period, as long as when was your LLC, formed?
I formed it after January 1st, but I did not, so what am I signing? Am I signing just my name?
Well, you're a member, so
Okay,
you're
so
signing.
just sign member?
Mhm.
Okay.
Yeah, if you're the only member, you're member managed. You could change it, make it manager managed, and make yourself a manager and sign as manager, but if you're the only member, you can sign it as
My
member.
only concern is personal versus company, so the title doesn't matter. I could sign it Empress if that's what.
I tried that, they didn't mention it. But no, you can just sign it member.
But if you have 5 members, all of them are the same rights?
That's what you'll outline in the operating agreement. You can sort of say certain acts by the company require unanimous voting, some require a majority vote. That's why sometimes it's good when people like doing the managing member, because we can say, we don't want to have to get everyone together to vote on this. We're going to let Daniela just be the managing member and do that. Just at that point, just create a manager. You can still, just like a corporation has, the board is allowed to do certain things, and it needs a vote of the shareholders. So same sort of thing. You could have a manager run the day-to-day of the LLC and the company, but for sort of major decisions, mergers, acquisitions, require unanimous or 2/3, sort of, that would all be outlined in the operating agreement.
If you're the only member of an LLC, how important is it to file this report at the end of the year?
It is
Annual report?
annual report. I'm glad you brought that up. Yes. So every year, so you file when you initially do an LLC. It's like $137.25 or 75 something. Every year, between January 1st and April, I think end of April, you have to file the annual report. It's $125 to file the annual report. Come May 1st, they add a $400 late penalty to $125, so it becomes $525. If you do not file the annual report by September, they will administratively dissolve your LLC, the state. They won't tell you, but if you go online, you'll see ADJ, or administratively dissolved. What that basically means is all of the protections of the LLC are gone. Your personal assets are now, once again, open if you're a company, because you have no protection. That shield is completely gone if you don't file the annual report. They've now added, before in 2010, there were ways around, you could ask them nicely, and for certain things they would get rid of the $400 fee. They have gotten rid of that statute. There is no way around it. If come May 1st, it becomes a $400 penalty, and if you don't file it by September, they'll administratively dissolve you. You can still tell everyone you're an LLC and think you're an LLC, but if you try to sue as that, or you get sued as that, or something happens, you're personally liable now because your LLC protection is completely gone. So it is very important.
What does that do to your fictitious name?
Well, fictitious name is different. That's a whole separate thing, whole separate tax code. So that's a good point. I'll bring that up too. So LLCs, we'll kind of talk about this. Every LLC has to be named, yada yada, whatever, LLC, or L.L.C. or limited liability company at the end. That has to be the technical name of every LLC. It's required. So my technical name, my official state name is Lawyer Mike D. PLLC, because I'm a professional limited liability company. But I don't want to go and put that out on my cards, and I don't want to say, hi, I'm Lawyer Mike D. with Lawyer Mike D. PLLC, even though it rhymes and I kind of like it. I just want to say I'm Lawyer Mike D. So you can file what's called a fictitious name, which is a DBA, doing business as. That requires more money to the state, obviously. You have to file a notice in the paper, and then it sort of links up and it connects. So you can still do business as, but the DBA has no sort of protection at all. That is just a take off the ending or call me this. I want to be known as, you know, cute lawyer. Doing business as.
Do business as
It's against the law in Florida.
Yeah, you have to have the LLC afterward.
No, to be called cute lawyer Michael D. It's
No, I
against the law.
I already got it. Don't worry.
Can you look up
Bruce has a
any,
question back here.
I know.
Okay.
Bruce is patient.
can anybody look up online who are LLCs and information about them? I mean,
Yes.
that-
Sunbiz.org, basically that's where you would go to register your LLC or have someone do it for you. But you can go and look up by name, you can look by registered agent, you can look by location, you can look by fictitious name, and you can see the articles of organization that were filed by the company and then every annual report. They have PDFs of it, that's public record. So you'll see basically who owns every LLC or company, who the registered agent is, where their primary place of business is, and all that is public knowledge. So then we'll kind of talk about one of the perks. A lot of people will say, you know what, I want to have an LLC, I don't want anyone to know about it, so Florida isn't the place for me. So we ship them out to Nevada because in Nevada you can be anonymous. You don't have to know who owns it, anything. It is more expensive because they know that they have that little niche market, but that is
That is an excellent reason to use Office Divvy services, because I initially set up my LLC operating out of my home, the home phone number. I've been using Office Divvy for, at least 5 years for my phone number and changed all the state filings. I'm still getting business solicitation phone calls to my home number.
So let me, here's a free nugget of knowledge because you all were so patient in this. So when some of you might be, it's hindsight, so 2020, but whenever you sign up, like I said, this is all public record. So there are companies that after you sign up on the Department of State will send you solicitations. Hey, give us $50, or it's just under $50, $47.99, and we'll send you your certificate of status. And it looks official, it looks like it's from the state. There is tiny print on the bottom there that says this is not affiliated with a government agency. It is a scam. You can get that certificate online for $25 if you really wanted it. You don't need it. If someone wants proof, then you would get it to prove that you're actually an entity. But every time that you sign up for it, you sign up for an LLC, a company, anything, you'll get solicitations from these people asking you for about $50. Usually 2 of them come, and they'll send you your certificate of status.
It looks like the seal, yeah.
Yeah, it has the seal, but there is a little print that says, and then actually, yeah, about this time of year, you'll get one for the annual filing report.
Yeah.
That's also not, like I'm a PLLC. I got a solicitation to file my annual minutes as if I was a corporation. So you'll notice very small print, and that's where a lawyer comes in handy, but that's free. That's some knowledge right there. Bruce, please.
You know that in the course of my work, working with businesses and people, we'll do buy-sell agreements. I don't write them, the lawyers do, but I can provide the insurance to fund them. So if a partner or a shareholder dies early, cash comes in to buy them out. Same way with disability. Also, there are key person insurance that you can put on an important employee. Has anything changed in the law for LLCs that affects that, or how decisions can be made about that?
As far as buying out the interest of the other party?
And or having the corporate ability to buy the insurance, or the individual ability.
Yeah, nothing was changed as far as that goes, because that wasn't regulated in the directly by statute, so that's still allowed, you can still do all
That's
that.
probably
That's
not
other business law.
LLCs either.
Yeah, no, it's not exclusive, yeah, that's sort of any corporation, that's all good, you're still
Okay,
doing.
well, pardon my curiosity, but.
No, that's a very important thing for you to know.
Really?
It's still legal to write in that any member who's dissociating has to offer the existing members the first right to buy their shares.
Yeah, so that's kind of goes into one of the other perks of an LLC is big corporation will use Coke again. Shareholders are sort of anyone in the world. It is public stock. It is traded freely, quickly. Everyone can buy it. With an LLC, with small businesses, small even corporations, people set them up a lot of times because they want to control who has ownership in it. As far as lawyer Mike D, PLLC goes, I love you all so much, but I don't want you to have any sort of say in what I do with my business. So yeah, the membership interest, you can restrict the transferability of that. And you can restrict, if something happens to me or I dissociate, I want the other members or the business itself to have right of first refusal to buy the membership. And that kind of sort of will come into the appraisal rights again and some of the things that will trigger that. But yeah, you're still allowed to keep the small business aspect of it and the closely held business. So you can decide who's an owner.
What is the role of the registered agent?
The role of the registered agent is to make sure that there is someone in the state in a physical location that can accept service of process. Basically, which means if there is any sort of legal action or the state needs to communicate in any sort of official legal capacity, the registered agent is that person that has a physical storefront. It's not a P.O. box, it has to be a physical location that will accept process, service of process on behalf of that company. Most people will make it the same company's location. Usually people will make it a different location, their attorney's office. I'm a registered agent for a lot of businesses, so I'll get any sort of process just because it'll end up in my office anyway. But you need to have a registered agent in Florida. Every state requires a registered agent. So like I said, Nevada, if you want to go and be an anonymous LLC out there, we can set that up for you. You need a registered agent. Well, I don't know anyone that lives in Nevada. I don't really trust anyone that wants to live in Nevada, so what do? There are companies that basically all they do is they act as all they are registered agents for hundreds of thousands of corporations. So they make a nice chunk of change off sort of just being a free door for someone out of state.
Can you, without changing your articles of LLC-ship, change the members of the LLC, increase and decrease them?
Mm-hmm. Yeah, and that'll sort of be outlined in the operating agreement how members can come in and come out. The original document with the state, you just need the one, and that's the only public document. The operating agreement will control any sort of addition of
Additions or
members.
deletions and
Yeah.
Should you, I don't know, probably not should you because it's probably different for everybody, but if you're a single member LLC, but you're married, is your spouse kind of automatically part of your business or no?
No.
So then what happens if something happens to you?
Well, that's all with the winding up of it. So the statute will fill in the gap if it's not in the operating agreement.
But I'm speaking to the statute, like what would happen if you don't really have if you're just like a lot of us are just a one person shop, and
I'd have to look up exactly, but my gut is basically it will wind up and then the assets will sort of go to the estate, if anything is sort of pay off.
What about liabilities though?
that was my question, the liability.
You won't ever get a personal liability. So if there's a liability and the company has no assets, you can't get anything. It's just like any sort of normal lawsuit. If I sue Mike because he hit me with his car and I got $1 million judgment from him, if he doesn't have $1 million, it does me no good to have it. So the same thing, that's what the LLC does is, basically if I'm rich, because hopefully one day I might someday in my dreams be, I want to have all those assets personally. I don't want to keep them in the company. So when lawyer Mike D blows up and you see me next to Morgan and Morgan on the billboards, I'm going to hopefully take all the assets that are in that and bring them personally. So if anything happens and someone realizes I don't know the law and sue me for malpractice, there's $40 in that bank account and you can have it. Other than that, you're kind of lost. So as far as the liability goes, you're still shielded off.
unless you fail to file by September.
Yes. and then you are administratively dissolved and personally liable, and then also divorced.
I was listening. Yeah, I wasn't asleep.
See?
regarding dissociation of multiple members, while you're free to leave the corporation or company at any time, you can still be held liable for assets, and I mean, not assets, but your liability is the company. Say the company's at a loss and your share of the loss is $100,000. You can't just bail.
Yeah, you can't sort of get out of the liability. That's one of the things that the new act sort of talks about, is that before it was very hard for a member to dissociate at all. Now they can freely sort of for any reason willfully dissolve. But yeah, there's still liability there. So if I join an LLC and I bind the company and all this stuff and then I say, sorry guys, I'm still liable for some of my actions there, the fiduciary duties and everything that I had, so.
What about the structure with multiple businesses? For example, I have holding companies, I'll set up holding companies, and then I have the operating company. So anything of any real value is in the holding company, and anywhere that I could get sued is over in the operating company. Do you set up sister brother style corporations or LLCs down here? Because I know some you could create the LLC and then you could partition it within the LLC and still have. You can do that in Delaware, for example.
Yeah.
But I don't know if did you guys finally adopt that, or did they not adopt it?
No. But there's ways sort of to kind of shield off the liability. You can set up the overall operating LLC and then each LLC underneath it. It's a little more cumbersome.
But you have to set up a separate LLC for everything rather than have, like a Delaware, you set up the one, and then you just can keep partitioning off up to as many as you want.
No, you'd have to create a separate
and then
one.
it can flow back to that separate holding one.
Yeah.
You don't have to, but each one is their own. Like you could have 20 pieces of real estate, each with its own liability.
Yeah, no, you have to
But
set
you
up
only
a
have
separate.
one filing fee.
I know. No, so that's another reason people will set up LLCs, the holding company, to buy real estate. So if people are investing in the real estate market, instead of me personally buying all these pieces of property, if something happens on that property, a tenant falls, something happens, I'm personally liable, they'll set up a separate LLC, and every rental property will be owned by, MD Holdings 1, MD Holdings 2, MD Holdings 3. So each one has its own house, and each one of those, the rent will file into there. Then I would take and give myself the distributions, making sure that there's $40 in here. So if something happens with the house, you can take the house, but you can't have any sort of the rent, the money from it. So people will set up an LLC to also protect themselves when they do real estate investments.
We set up the operating company that leases, and then they lease from the operating company. So they can't even go, if they sue, the most they can do is go after the operating company. They can't even go after the house itself.
Yeah, so
So it's we have an extra level.
Yeah, so I've set up companies who bought a building and then leased the building to another holding company who then subleased it to a business that was renting it. Yeah, there are ways to, for enough money and enough sort of time, we can sort of protect you and sort of.
That's why I went to Delaware, but you guys didn't adopt it, but I'm in Florida now.
So there's no way they can get to you? Doesn't matter what you own?
Well,
Because your name is going to be on each and every LLC, right?
unless you set it up in Wyoming or Nevada or somewhere where I can set up with an anonymous, and I can sort of put it make the trail go cold. Keep this in mind now. Like I said at the beginning, there has to be a separation of sort of things. So if I set up Lawyer Mike DP LLC and I have my one bank account and I run everything through that and I buy my groceries and I pay my rent and then I get lawyer fees and then I pay my legal fee, my subscription fees with it. I no longer really have set up an LLC. I have it, but I haven't set up any sort of separate thing. So when you set up the LLC with the state, get a new tax ID from the IRS, set up a bank account that's separate, keep all of your expenses separate. Otherwise, there's what's called, you could be subject to liability because there's really no LLC. They can pierce the corporate veil, basically, and sort of there is a way. If you commingle enough and really sort of make that line between business and personal, so gray that it's white, they'll come after you and get your personal assets. So it's